never heard of me, you're about to in the days to come, the weeks to come, know who I am, the kind of work I do. Let me show you this memo. I spoke to the New York City Board of Election. I set them up in a sting. This is federal court. I took them to federal court on the 12th of August. And on this day, candidates seeking public office in the city of New York can take them to court and sue them for every dime they got. Why? Because on August 12th, at 4 p.m. in 2009, they admitted to violating the state's constitution of weighing petitions and opposition of candidates getting on the ballot. I don't know if they made a mistake or something, I don't know. But they admitted to doing it. And they spoke and gave the judge a justified reason for doing it. Do you understand how silly they are? They admitted, I set a trap and they fell in it. Boy, it must be good. I hope you all can, this place needs to be straightened out. God, y'all help me get this done. The transcripts are in federal court. I was going to get it, but it cost too much money. Rent is too damn high and I couldn't afford that. As long as I have all the information to give anyone who got the money to get the transcript, to take it to the next level. I wanted to give it, thought about the Attorney General, but those people they're hard to work with, man. I wrote letters and they haven't answered a letter I wrote yet about anything that I'm doing. The only thing they answered is when I filed an order to show cause in federal court against what they did to me. But once again, the New York City Board of Election on August 12th of 2009, I took them to federal court in room 10D. And in that courtroom on that day, the New York City Board of Election admitted a guilt of being the oppositioner against candidates getting on the ballot through process of weighing the petitions to see if the candidates have enough. So here's what the Board of Elections has been doing. You don't have enough signatures. They call in an oppositioner to justify that the opposition has just popped up to challenge your petition. But the Board of Election has been doing it. But wait a minute. You don't have to be a rocket scientist to figure this out. Who are they doing it for? Once again, somebody getting paid. Somebody got paid. Somebody help me. That's all I can say. I want you to run for public office, and I want you to help me straighten this corruption out in this state. Election Ponzi. An election Ponzi by the commissioners of election. You know, God damn. Listen, y'all go ahead on. Look at the other tape I got behind me here. There's another tape talking about some issues. I'm talking about some of this, but I needed to show you these legal papers so you know that I'm not playing. Good afternoon. This is Jimmy McMillan, founder of the Rent Too Damn High movement and party, and also the creator of the 3 easy step process petitioning method. On June 16, I took the federal New York State Board of Elections to court, really, in the Eastern District on deprivation of rights under federal statute. And we're waiting for the judge's decision, so we can't celebrate too much, but some things we can talk about. The New York State Board of Election has allowed parties, selected parties, to appear on the ballot violating the state law with more than 15 characters. And the judge noted that yesterday on the 16th. Asked them if they did. They admitted they did. And the question to that is, why did they take damn out the Rent Too Damn High party name? That had 17 characters, the same as some of the other parties that were there. they didn't have an answer for it. So the Rent Too Damn High Party going to have a new look on the ballot, but it will still be the number 2, the letter 2, T-O-O, but it will be the number 2 on the ballot. Rent is too damn high. So the judge asked me if it was okay, if I accept that. I say yes. So the Attorney General's office agreed they would accept it too. So that's the way it will be. The New York City and New York State Board of Elections have a few problems that need to be corrected. And after the judge's decision, I'll be able to address more of what happened on the 16th of June. Okay, so let me move forward from here. Let me talk about the New York City Board of Elections. I need all the political parties involved to get serious. What happened in 2009, the New York City Board of Election set up a conspiracy against all the parties that had extended names. And the reason that was is to get a Democratic candidate elected, because the other parties was drawing too much attention. To shorten the name, confuse the voters. And the same people, New York City and New York State, is not communicating at all. This is a violation in itself. Of the state has the authority. Whatever the state says on the ballot, New York City has to agree. But New York City went on their own. And the state don't even know, didn't know they did it. Like as though we can do what we want to do. No, you can't. I'm looking for you to take them to court. I'm looking at the ballot